We rolling? Damn fleas. Let the dog in here. Lord. We rolling? What's going on? Alright. Alright, now listen up. There's word getting out about the project. We don't need that. Nobody, on top of everything else, nobody talks to the press, okay? Nobody. Even when it's released, nobody talks to the press. You guys got it? Remember, the puppet speaks for itself. We rolling? Okay, here we go. One, background, legal, and evidentiary principles. A, legal framework of obstruction of justice. The May 17, 2017 appointment order and the special counsel regulations provide this office with jurisdiction to investigate federal crimes committed in the course of and with intent to interfere with the special counsel's investigation, such as perjury, obstruction of justice, destruction of evidence, and intimidation of witnesses. 28 CFR section 604A. Because of that description of our jurisdiction, I can't read the thing. Can you fix that? Oh, that's great. You messed with the Zoom, didn't you? You did. Now look at you. We're rolling. Do something. Oh, that was brilliant. Maybe I can tell a few jokes. Do I know any Russian jokes? I know.
My God.
I think you fixed it? I don't know where you are now. You better tell some jokes. I better tell some jokes. Somebody tell some jokes around here. Did you hear about the Russian guys that worked at the watch factory? Yeah. So they had these 3 Russian guys, see. They're working at the watch factory. And one guy shows up early, and one guy shows up late, and one guy shows up on time. And they fire the guy that shows up late for showing up late. They fire the guy that shows up early for having a watch from their factory. And they fire the guy who shows up on time for having an American watch. You fix that thing yet? That looks better. Okay. Can you get it to scroll? Get it to scroll. I think I got a Russian running this thing. Okay, here we go. Now where was I? Oh, 28 CFR section 604A. Because of that description of our jurisdiction, we sought evidence for our obstruction of justice investigation with the elements of obstruction offenses in mind. Our evidentiary analysis is similarly focused on the elements of such offenses, although we do not draw conclusions on the ultimate questions that govern a prosecutorial decision under the principles of federal prosecution. See Justice Manual, section 9-27000 at sec 2018. Here, we summarize the law interpreting the elements of potentially relevant obstruction statutes in an ordinary case. This discussion does not address the unique constitutional issues that arise in the inquiry into official acts by the President. Those issues are discussed in a later section of this report addressing constitutional defenses that the President's counsel has raised. See Volume 2, Section 3B info. 3 basic elements are common to most of the relevant obstruction statutes. 1. An obstructive act. 2. A nexus between the obstructive act and an official proceeding. And 3. A corrupt intent. See e.g. 18 U.S.C. Section 1503, 1505, 1512 C2. We describe those elements as they have been interpreted by the courts. We then discuss a more specific statute aimed at witness tampering, see 18 U.S.C. Section 1512B, and describe the requirements for attempted offenses and endeavors to obstruct justice, see 18 U.S.C. Section 1503, 1512 C2. Obstructive act. Obstruction of justice law reaches all corrupt conduct capable of producing an effect that prevents justice from being duly administered regardless of the means employed. United States v. Silverman, 745 F2D 1386, 1393, 11th Circuit, 1984, interpreting 18 U.S.C. Section 1503. An effort to influence a proceeding can qualify as an endeavor to obstruct justice even if the effort was subtle or circuitous, and however cleverly or with whatever cloaking of purpose it was made. United States v. Roe, 529 F2D 629, 632, 4th Circuit, 1975. See also United States v. Quattrone, 44 F3D 153, 173, 2D Circuit, 2006. The verbs obstruct or impede are broad and can refer to anything that blocks or makes difficult or hinders. Martinello v. United States 138, South Circuit, 1101, 1106, 2018. Internal brackets and quotation marks omitted. An improper motive can render an actor's conduct criminal even when the conduct would otherwise be lawful and within the actor's authority. See United States v. Cueto, 151 F3D 620, 631, 7th Circuit, 1998. Affirming obstruction conviction of a criminal defense attorney for litigation-related conduct. United States v. Santolo, A18 F2D 980992, 1st Circuit Court, 1987. Any act by any party, whether lawful or unlawful on its face, may abridge Section 1503 if performed with a corrupt motive. Nexus to a pending or contemplated official proceeding. Obstruction of justice law generally requires a nexus or connection to an official proceeding. In Section 1503, the nexus must be pending judicial or grand jury proceedings. United States v. Aguilar, 515 U.S. 593. That'll be 594, right? 599. Yeah, I misspoke on that one. 1995. In Section 1505, the nexus can include a connection to a pending federal government agency proceeding or a congressional inquiry or investigation. Under both statutes, the government must demonstrate a relationship in time, causation, or logic between the obstruction act and the proceeding or inquiry to be obstructed. It at 599. See also Arthur Anderson, LLP versus United States, 544, U.S. 696, 707, 708, 2005. Section 1512C prohibits obstructive efforts aimed at official proceedings, including judicial or grand jury proceedings. 18 U.S.C. Section 1515A 1A. For purposes of Section 1512, an official proceeding need not be pending or about to be instituted at the time of the offense. 18 U.S.C. Section 1512F1. Although a proceeding need not already be in progress or trigger liability under Section 1512C, a nexus to a contemplated proceeding still must be shown. United States v. Young, 916 F3D 368 386, 4th Circuit, 2019. United States v. Petrek, 781 F3D 438 445, 8th Circuit, 2015. United States v. Phillips, 583 F3D 1261 1264, 10th Circuit, 2009. United States v. Wrights, 479 F3D 179 186, 2nd D Circuit, 2007. The nexus requirement narrows the scope of instruction statutes to ensure that individuals have fair warning of what the law prescribes. Aguilar, 515 U.S. at 600. Internal quotation marks omitted. Excuse me. The nexus showing has subjective and objective components. As an objective matter, Defendant must act in a manner that is likely to obstruct justice, such as the statute excludes defendants who have an evil purpose, but use means that would only unnaturally and improbably be successful. Aguilar 515 U.S. at 601-602, emphasis added, internal quotation marks omitted. The endeavor must have the natural and probable effect of interfering with due administration of justice. Is at 599, citation in internal quotation marks omitted. As a subjective matter, the actor must have contemplated a particular foreseeable proceeding. Petrick 781 53D at 445 446. The defendant need not directly impede the proceeding. Rather, a nexus exists if discretionary actions of a third person would be required to obstruct the judicial proceeding if it was foreseeable to the defendant that the third party would act on the defendant's communication in such a way as to obstruct the judicial proceeding. United States v. Martinez, 862, F3D, 223, 238, 2nd Circuit, 2017. Brackets, ellipses, and internal quotation marks omitted. I should omit these brackets, ellipses, and internal quotation marks myself. Corruptly. That's a good word. The word corruptly provides the intent element for obstruction of justice and means acting knowingly and dishonestly and with an improper motive. United States v. Richardson, 676, F3D, 491, 508, 5th Circuit, 2012. United States v. Gordon, 710, 53D, 1124, 1151, 10th Circuit, 2013. To act corruptly means to act with an improper purpose and to engage in conduct knowingly and dishonestly with the specific intent to subvert, impede, or obstruct the relevant proceedings. See 18 U.S.C. Section 1515B. As used in Section 1505, the term corruptly means acting with an improper purpose, personally or by influencing another. See also Arthur Anderson 5444 U.S. at 705, 706. Interpreting corruptly to mean wrongful, immoral, depraved, or evil. And holding that acting knowingly, corruptly in 18 U.S.C. Section 15.2b requires consciousness of wrongdoing. The requisite showing is made when a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and the rights of others. Valentine's Law, Dictionary 276, 3D edition, 1969. See United States v. Pasha, 797 F3D, 1122, 1132, DC Circuit, 2015, Aguilar 515 U.S. at 616, Scalia Jr., concurring in part and dissenting in part, characterizing this definition as the long-standing and well-accepted meaning of corruptly. Witness tampering. A more specific provision in Section 1512 prohibits tampering with a witness. See 18 U.S.C. Section 1512B13, making it a crime to knowingly use intimidation or corruptly persuade another person or engage in misleading conduct towards another person. I should have got that one. With the intent to influence, delay, or prevent the testimony of any person in an official proceeding, or to hinder, delay, or prevent the communication to a law enforcement officer of information relating to the commission or possible commission of a federal offense. To establish corrupt persuasion, it is sufficient that the defendant ask a potential witness to lie to investigators in contemplation of a likely federal investigation into his conduct. United States v. Edlin, 887, F3D, 166, 174, 4th Circuit, 2018, United States v. Sparks, blah, blah, blah. I'm going to skip all the blah. There's a zillion of these. Okay, you can't witness tamper, okay? Everybody got that? The persuasion need not be coercive, intimidating, or explicit. It is sufficient to urge, induce, ask, argue, give reasons, Sparks 791 F3D at 1192, or coach or remind witnesses by planting misleading facts. Edlin 887 F3D at 174. Corrupt persuasion is shown where a defendant tells a potential witness a false story as if the story were true, intending that the witness believe the story and testify to it. United States versus Woodall, it's 786 F2D 7782 7th Circuit 1986 United States versus Gabriel 125 F3D 89 102 2nd Circuit 1997. It also covers urging a witness to recall a fact that the witness did not know, even if the fact was actually true. See Lachey 417 F3D at 719. Corrupt persuasion can also be shown in certain circumstances when a person with an improper motive urges a witness not to cooperate with law enforcement. See United States versus Schatz 145 F3D 1289 1301 11th Circuit 1998. Telling secretary not to say anything to the FBI and she would not be bothered. Read that again. Telling secretary not to say anything to the FBI and she would not be bothered. There's a line for you. When the charge is acting with the intent to hinder, delay, or prevent the communication of information to law enforcement under Section 1512b3, the nexus to a preceding inquiry articulated in Aguilar that an individual does not have knowledge that his actions were likely to affect the judicial proceedings, 515 U.S. at 599, does not apply because the obstructive act is aimed at the communication of information to investigators, not at impending an official proceeding. Acting knowingly, corruptly, requires proof that the individual was conscious of wrongdoing, Arthur Anderson, 544 U.S. at 705, 706. Declining to explore the outer limits of this element, but indicating that an instruction was infirm when it permitted conviction even if the defendant honestly and sincerely believed that the conduct was lawful. It is an affirmative defense that the conduct consisted solely of lawful conduct and that the defendant's sole intention was to encourage, induce, or cause the other person to testify truthfully. Attempts and endeavors. Section 1512c2 covers both substantive obstruction offenses and attempts to obstruct justice. Under general principles of attempt law, a person is guilty of an attempt when he has the intent to commit a substantive offense and takes an overt act that constitutes a substantial step towards that goal. So United States versus Vincendez Pons, 549, U.S. 102, 106, 107, 2007. The act must be substantial and that it was strongly corroborative of the defendant's criminal purpose. United States versus Pratt, 351, F3D, 131, 135, 4th Circuit, 2003. While mere abstract talk does not suffice, any concrete and specific acts that corroborate the defendant's intent can constitute a substantial step. United States versus Irving, 665, F3D, 1184, 1198, 1205, 10th Circuit, 2011. Thus, soliciting an innocent agent to engage in constituting an element of the crime may qualify as a substantial step. Model Penal Code 502G, see United States versus Lucas, 499, F3D, 769, 781, 8th Circuit, 2007. Yeah. Fascinating stuff. I like that line about don't talk to the FBI, you won't be bothered. The Omnibus Clause of 18 U.S.C. Section 1503 prohibits an endeavor to obstruct justice, which sweeps more broadly than Section 1512's attempt provisions. See United States versus Sampson, 898, F3D, 287-302, 2nd Circuit, 2018, United States versus Leisure, 844, F2D, 1347, 1366, 1367, 8th Circuit, 1988, collecting cases. It is well established that an obstruction of justice offense is complete when one corruptly endeavors to obstruct or impede the due administration of justice. The prosecution need not prove that the due administration of justice was actually obstructed or impeded. United States versus Davis, 854, F3D, 1276, 1292, 11th Circuit, 2017. B. Investigative and evidentiary considerations. After the appointment of the special counsel, this office obtained evidence about the following events related to the potential issues of obstruction of justice involving the president. A. The president's January 27, 2017 dinner with former FBI Director James Comey, in which the president reportedly asked for Comey's loyalty one day after the White House had been briefed by the Department of Justice on contacts between former National Security Advisor Michael Flynn and the Russian ambassador. B. The president's February 14, 2017 meeting with Comey, in which the president reportedly asked Comey not to pursue an investigation of Flynn. C. The president's private request to Comey to make public the fact that the president was not the subject of an FBI investigation and to lift what the president regarded as a cloud. D. The president's outreach to the Director of National Intelligence and the directors of the National Security Agency and the Central Intelligence Agency about the FBI's Russia investigation. We got enough letters in the alphabet for this thing? E. The president's stated rationales for terminating Comey on May 9, 2017, including statements that could reasonably be understood as acknowledging that the FBI's Russia investigation was a factor in Comey's termination. And F, I think, the president's reported involvement in issuing a statement about the June 9, 2016 Trump Tower meeting between Russians and senior Trump campaign officials that said the meeting was about adoption and admitted that the Russians had offered to provide the Trump campaign with derogatory information about Hillary Clinton. Taking into account that information and our analysis of applicable statutory and constitutional principles as discussed below in Volume 2, Section 3 Infra, we determined that there was a sufficient factual and legal basis to further investigate potential obstruction of justice issues involving the president. Many of the core issues in an obstruction of justice investigation turn on an individual's actions and intent. We therefore requested that the White House provide us with documentary evidence in its possession on the relevant events. We also sought and obtained the White House's concurrence in our conducting interviews of White House personnel who had relevant information. And we interviewed other witnesses who had pertinent knowledge, obtained documents on a voluntary basis when possible, and used legal process where appropriate. These investigative steps allowed us to gather a substantial amount of evidence. We also sought a voluntary interview with the president. After more than a year of discussion, the president declined to be interviewed. Grand jury? Grand jury has to do with his interview? I hope there's not many more of those. During the course of our discussion, the president did agree to answer written questions on certain Russia-related topics, and he provided us with answers. He did not similarly agree to provide written answers to questions on obstruction topics or questions on events during the transition. Ultimately, while we believe that we had the authority and legal justification to issue a grand jury subpoena to obtain the president's testimony, we chose not to do so. We made that decision in view of the substantial delay that such an investigative step would likely produce at a late stage in our investigation. We also assessed that based on the significant body of evidence we had already obtained of the president's actions and his public and private statements describing or explaining those actions, we had sufficient evidence to understand relevant events and to make certain assessments without the president's testimony. The office's decision-making process on this issue is described in more detail in Appendix C, Infra, and a note that precedes the president's written response. In assessing this evidence we obtained, we relied on common principles that apply in any investigation. The issue of criminal intent is often inferred from circumstantial evidence. See United States v. Corcho, 819 F3D 1293 1305 11th Circuit 2016. Guilty knowledge can rarely be established by direct evidence. Therefore, mens rea elements such as knowledge or intent may be proved by circumstantial evidence. United States versus Robinson. I'm omitting the eternal question marks that are omitted. United States versus Robinson, 702 F3D 2236, 2nd Circuit 2012. The government's case rested on circumstantial evidence, but the mens rea elements of knowledge and intent can often be proved through circumstantial evidence and the reasonable inferences drawn therefrom. The principle that intent can be inferred from circumstantial evidence is a necessity in criminal cases, given the right of a subject to assert his privilege against compelled self-incrimination under the Fifth Amendment and therefore decline to testify. Accordingly, determinations on intent are frequently reached without the opportunity to interview an investigatory subject. Obstruction of justice cases are consistent with this rule. See e.g. Edlin 887 F3D at 174-176, relying on significant circumstantial evidence that the defendant was conscious of her wrongdoing in an obstruction case. Because evidence of intent will almost always be circumstantial, a defendant may not be found culpable where the reasonable and foreseeable consequences of her acts are the obstruction of justice. Internal quotation marks, blah, blah, blah. Quattrone 441 F3D at 173-174. Circumstantial evidence that illuminates intent may include a pattern of potentially obstructive acts. Federal 44B, evidence of a crime, wrong, or other act may be admissible, but to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. See United States v. Frankhauser, 80 F3D, 641, 648, 650, First Circuit, 1996, and about 3 more cases. Credibility judgments may also be made based on objective facts and circumstantial evidence. Standard jury instruction highlight a variety of factors that are often relevant in assessing credibility. These include whether a witness had a reason not to tell the truth, whether the witness had a good memory, whether the witness had the opportunity to observe the events about which he testified, whether the witness's testimony was corroborated by other witnesses, and whether anything the witness said or wrote previously contradicts his testimony. CEG First Circuit Pattern Jury Instructions, Section 106, 2018, Fifth Circuit Pattern Jury Instructions, Criminal Cases, Section 108, 2012, Seventh Circuit Pattern Jury Instructions, 301, 2012. In addition to these general factors, we took into account more specific factors in assessing the credibility of conflicting accounts of the facts. For example, contemporaneous written notes can provide a strong corroborating evidence. See United States versus Nobles 422, U.S. 225, 232, 1975. The fact that a statement appeared in the contemporaneously recorded report would tend to strongly corroborate the investigator's version of the interview. Similarly, a witness's recitation of his account before he had any motive to fabricate also supports the witness's credibility. See Tome versus United States 513 U.S. 150, 158, 1995. A consistent statement that predates the motive is a square rebuttal of the charge that the testimony was contrived as a consequence of that motive. Finally, a witness's false description of an encounter can imply consciousness of wrongdoing. See Al-Ahadi versus Obama, 613 F3D 1102, 1107, DC Circuit 2010, noting the well-settled principle that false exculpatory statements are evidence, often strong evidence of guilt. We applied these settled legal principles in evaluating the factual results of our investigation. That we did. Oh, white space there. Probably at the end of this section. Yeah, we're at the end of that section. So let's take a little break and we'll come back for factual results of obstruction investigation. Are we done? Donald Trump ignores me and I don't know why. Everything the Trumpster hates rolled up into one guy. I'm sleepy and I'm nasty and I'm shady too, but not recused like Sessions. Was his name Magoo? Just like Crooked Hillary or maybe Lying Chuck. But no matter what I try, Don don't give a fuck, but I ain't no nervous Nancy or no sleazy Adam Schiff. Someone tell me how to get this ass to give a shit. I'm all for higher taxes and I'm all for higher crime. Think cheating Obama did the job just mighty fine. I like crazy Bernie, I like Pocahontas too. Just like Dickie Durbin, I ain't your mama's fool. Donald Trump ignores me and I don't know why. I'm everything the Trumpster hates rolled up into one guy. Lying, leaking, heartless, slimeball, slippery, sanctimony